Hello there. My name is Allison Wright, and I'm a partner and shareholder at the law firm of Pappas Wright, located in Rock Island, Illinois. I'm pleased to be here today providing a podcast to you on behalf of the Illinois Community College Trustees Association. This podcast is being recorded at Blackhawk College campuses. Today's podcast, we're going to be talking about one of the sunshine laws in the state of Illinois, the Freedom of Information Act, commonly referred to as FOIA. So what we're going to be talking about is what it is, who it applies to, what records constitute public records, which ones don't, what exceptions apply, and then of course at the end we're going to circle back and talk about how you can implement those rules into your everyday governance as trustees. For this podcast, we are going to talk about the Open Meeting Act's counterpart within the Sunshine Law package, the Freedom of Information Act. Of course, both OMA and FOIA are referred to as sunshine laws because they are both laws intended to shine the light in or promote transparency of governmental public business. And in other trainings, we've talked about the Open Meetings Act and the QB rule to help trustees determine when the act applies to communications amongst or between trustees. And for this segment, we are going to use that same principle in determining what documents are open to the public. Now, none of you as trustees are responsible for receiving or responding to FOIA requests submitted to your college. So this training is different than the one your FOIA officers should receive. But as trustees, you are, of course, privy to all the information of the college, and as you communicate, create documents, or come in possession of college records, it is incredibly important to understand when FOIA applies. Now, very briefly, here are the 5 main topics we will quickly cover in this FOIA training. First and foremost, what is it? What is the Freedom of Information Act? Secondly, we're going to talk about when it applies. Third, we're going to take a look at what fits in our FOIA cup, our CUP. You will see if it fits in our FOIA cup, then FOIA applies. Then we are going to take a look at records that are exempt from disclosure. And lastly, we will recap the key trustee takeaways from today's segment. So let's take a look at the law itself. What is FOIA? Before we get into the logistics, I'm going to give a brief overview of what FOIA is. The Illinois Freedom of Information Act became law in 1984. Interestingly, Illinois was the last of the 50 states to enact a Freedom of Information Act. Before the state passed FOIA, the state had the State Records Act and the Local Records Act, which mostly provided access to financial records. The State and Local Records Act did not provide the broad access that FOIA ultimately provided. When FOIA was enacted, the statute specifically superseded those 2 state laws. So while they both still remain in existence and they govern the retention and destruction of public records, FOIA is now the exclusive state law on freedom of information. Over time, since 1984, there have been a few amendments to FOIA, but they have mostly pertained to Section 7, which sets forth the various exemption categories. In 2009, FOIA went through its most substantial changes since its enactment. Public policy was clearly declared as favoring disclosure. The Act's public policy was amended to reinforce that the state's public policy favors disclosure, and to the opposite of that, exemptions from disclosure are to be construed narrowly. Acknowledged technological advances allowed for responses to become electronic. Section 7 went from having per se exemptions to imposing a balancing test. And finally, in 2009, the amendments created the Public Access Counselor's Office within the Office of the Illinois Attorney General. The Public Access Counselor is the office in charge of handling complaints alleging public bodies have violated OMA or FOIA in some way. The PAC requires complaints alleging violations be brought within 60 days, and if more than 60 days have passed, the violation cannot be reviewed. So much like OMA, we need to look at the definitions within FOIA to get our trustee tips on how FOIA impacts you as a board member. Turning first to what it covers. Put most simply, it applies to public bodies and public records, which includes community colleges, of course, and many of the records related to college business. And now let's break down who it applies to. The statute applies to public bodies, which are defined as legislative, executive, administrative, or advisory bodies of the state, state universities and colleges, counties, townships, cities, villages, incorporated towns, school districts, and all other municipal corporations, boards, bureaus, committees, or commissions of this state. Any subsidiary bodies of any of the foregoing, including but not limited to committees and subcommittees thereof. Now, this is a very long, wordy definition, but just like OMA, we know public body includes community colleges, and thus, FOIA applies to Illinois public community colleges, your board, and any committees or subcommittees of your board. And now the more substantial definition from FOIA is public records, meaning which records does the Act apply to? FOIA defines public records as all records, reports, forms, writings, letters, memoranda, books, papers, maps, photographs, cards, tapes, recordings, electronic data, processing records, electronic communications, recorded information, and all other documentary materials pertaining to the transaction of public business, regardless of physical form or characteristics, having been prepared by or for, or having been or being used by, received by, in the possession of, or under the control of any public body. I have to laugh because, again, this is very wordy, but that's okay. We're going to break that definition down just like we did to get to the QB rule in the Open Meetings Act training. And so here, we're going to take this lengthy definition and break it into three main counterparts. FOIA applies to all information pertaining to the transaction of public business that is prepared by or for, used by, received by, in the possession of, or under the control of a public body. Now, if you'll remember, each portion of a definition can take on its very own meaning. And here I simply point out that to be a public record, Illinois courts have told us that it must pertain to the business or community interests as opposed to private matters. So this slide includes a few examples of the different types of information that fall into those categories. You'll see for private matters, it refers to childcare needs, medical information, plans to attend a wedding, or a trustee's primary employment, while public business would refer to things like hiring of a new faculty member, adding a new college program, purchasing new equipment, or even constructing a new campus building. Now, just like the OMA training, my hope is to take the lengthier statutory language and condense it into a short enough format that you can actually remember it and use it. So today I would like to introduce you to the FOIA Cup. It has a nice big shining sun on it to represent all that transparency and light that FOIA extends to community college information. And of course, we know that if the information regarding college business fits into your FOIA Cup, then FOIA applies. So what goes in our FOIA Cup? Well, any information regarding the transaction of college business that CUP is created by or for the college, is used by the college, or is possessed or controlled by the college. Now, you can't control something unless you possess it, so I always include those two together. So here, the C is for created, the U is for used by, and the P is for possessed by. And when we think about the very broad scope of FOIA's application, this FOIA Cup helps us remember if it does not fit in our FOIA Cup, then FOIA does not apply. Now on this slide, I just give some examples of documents that will easily fit into that FOIA Cup. These include things like emails between community college employees, emails between community college trustees, settlement agreements, disciplinary action notices, purchase agreements, or other records relating to public funds. And FOIA does include a list of documents that are per se subject to FOIA disclosure. The statute provides a few types of records that are explicitly stated as public records under the Act. Those include things like arrest and criminal history records, settlement and severance agreements, and notably, since this applies to community colleges, any settlement or severance agreement entered into by an intergovernmental risk management association or a self-insurance pool is still covered by FOIA. So when such an association or consortium settles a harassment suit, that settlement agreement is subject to FOIA. And then lastly, records relating to public funds, of course. Now, we just talked about what FOIA is and who it applies to. We also talked about what records it covers. Next, we're going to talk about the exceptions in the statute, which exempt certain records from disclosure in response to a request. Now, outside of those specific types of records, we know that any information in tangible form, whether stored electronically or otherwise, that pertains to the transaction of community college business is subject to FOIA so long as it fits in our FOIA Cup. But this wouldn't be a legal training if there weren't some exceptions to the rule we just learned. So even when those definitional requirements are met, we know the statute provides various categories of records that are exempt from FOIA, which means that even if they meet the definition, they are not subject to public disclosure. Now, just like OMA allows trustees to convene in closed session to discuss specific matters privately, FOIA provides a list of exceptions for certain records that the state has deemed appropriate to keep confidential. So to be clear, when I say exception, I mean a record that otherwise qualifies as a public record under the Act, that is exempt from public disclosure because the state legislature feels it is in the best interest of the public body to maintain confidentiality of those records. So what are those exceptions? Well, on this slide, I've included a list of most of the exceptions under FOIA. I'd point out that some of them have numerous additional exceptions built into them, such as the very first one, which excludes any record prohibited from disclosure by state or federal law. Now, we're not going to walk through all of these exceptions, but I do want to highlight some of the main ones that come into play for many community colleges in this state. The first provision is Section 7, states that any information specifically prohibited from disclosure by federal or state law, or the rules or regulations implementing federal or state law, is exempt from public disclosure. This means if a federal or state law prohibits certain information from being disclosed, it doesn't have to be turned over for FOIA requests. Examples include FERPA and HIPAA. Now, relying on FERPA to deny FOIA requests has been the issue of much litigation in numerous cases, and many involving the University of Illinois. We know FERPA defines education records as any record that contains information directly related to a student that is maintained by the educational institution or a person acting for the institution. And that's a really broad standard. And if looking at when FERPA applies, we know that it applies to lots of information. However, the Illinois Public Access Bureau has chiseled away at FERPA and has concluded over time through various decisions that some information regarding students is subject to disclosure. This includes things like the names of students, their graduation information, degrees received, and even photos of students have been found by the Public Access Counselor to be directory information. Now, the next category of exemptions I want to touch on is employee information, especially because your board will likely be involved in various personnel matters, whether it be hiring, firing, or discipline. Records are often created throughout the course of any decision-making process. So what does FOIA say about employee information? Well, until 2010, employee personnel files were completely exempt under FOIA. After an amendment in 2010, the exemption was eliminated, so personnel records as a whole could be subject to disclosure. But in response to that, the Illinois legislature hung their hat on the first exemption we just talked about, where information is prohibited from disclosure under any state or federal law. And after eliminating the personal file exemption, the Illinois legislature amended the Personnel Record Review Act so that it prohibited the disclosure of performance evaluations. And the personnel record has another limitation on FOIA with regard to disciplinary records. Under Section 8 of the Personnel Record Review Act, only disciplinary records that are less than 4 years old may be disclosed in response to a FOIA request. If a disciplinary record, which is defined to include disciplinary reports, letters of reprimand, and other records of disciplinary action, is more than 4 years old, it is exempt from disclosure under FOIA. Now, of course, employees are one major population of any community college, but let's not forget while we're all here for our student populations. So the next exemption I want to talk about is general records that are exempt under Section 7(1)J for educational records. Specifically, FOIA exempts 4 separate categories of educational records. These include test questions, scoring keys, examination data used to administer an academic examination, course materials or research materials used by faculty members, information received by a college under its procedures for the evaluation of faculty members by their academic peers, and information related to a school or university's adjudication of student disciplinary cases. Now, the next exception I want to talk about is legal advice records. Under FOIA, there are 3 main categories of documents that are exempt that relate to legal advice. The first are communications between the public body and its attorney that would not be subject to discovery in litigation. This includes all communications covered by the attorney-client privilege. If the attorney-client privilege applies, FOIA honors that privilege and protects that information from disclosure. The second is materials prepared or compiled by or for a public body in anticipation of a criminal, civil, or administrative proceeding upon the request of an attorney advising the public body. And the last are materials prepared or compiled with respect to internal audits of public bodies. Now, this exemption assures community colleges and each of you that you can seek candid legal advice and that you can communicate freely without any cause for concern regarding that information or that email being subject to FOIA. In practice, FOIA must always be part of the analysis and determining strategy. Determining who is involved in an investigation, who controls it, who is directing what information to be compiled, all become relevant to protecting critical information that could possibly expose your college as you work towards a decision or specific course of action. Now, the last exemption I want to talk about is what I call the deliberative process exception. Now, please note that FOIA doesn't call it that, but our Illinois state and federal courts have mirrored what we know as the deliberative process privilege when deciding FOIA cases that involve Section 7(1)(f). And it states that preliminary drafts, notes, recommendations, memoranda, and other records in which opinions are expressed or policies or actions are formulated, except that a specific record or relevant portion of a record shall not be exempt when it is publicly cited and identified by the head of the public body. So, of course, to break that down, the exemption is really a three-part test we look at, and it exempts preliminary drafts, notes, recommendations, memoranda, or other records where opinions are expressed or policies or actions are formulated that has not been publicly cited and identified by the head of the public body. Now, this exemption applies to a lot of records within any community college. And the reason for that is obvious. With all the processes and procedures in place and the nature of any community college, of course, these are very, very dynamic institutions. You have decisions being made for employees, for students, for members of the public, and there are a lot of stakeholders, lots of moving parts. It would be a rare occurrence to find a decision that involved no preliminary notes or draft regarding the action to be taken. And while the third part of that exception refers to the head of the public body as a singular form, it of course includes the president. It's important to note the definition also refers to other individuals holding executive and administrative authority for the public body. So as a trustee tip, be sure to be cognizant of acknowledging or citing specific records, whether it be an open session at a meeting or otherwise, because your acknowledgement of that record could impact the college's ability to preserve its confidentiality as necessary under FOIA. Now, this podcast included learning the ins and outs of FOIA's reach. As trustees, you're all required to complete the state's FOIA training, and some of this may have been a simple refresher on some of those details. But to conclude this podcast, I would just remind you of a few main trustee takeaways regarding FOIA. When evaluating whether FOIA applies to information or records, don't forget to see if it fits in your FOIA cup. If it's information in some tangible form regarding the transaction of college business, it will only fit in your FOIA cup if the record was created by or for the college, was used by your college, or is in the possession or control of your college. And once that information fits in your FOIA cup, it is open to the public for inspection and copying. But if you're anything like me and you want that entire cup of coffee to yourself, remember, even if that information fits in your FOIA cup, it is not subject to public disclosure if any of the exemptions apply. And the exemptions are not just for the FOIA officer to evaluate at the time of a request. The rules of FOIA should be well known and understood, and they should be considered in your daily operations so you're aware of exactly what documents or records would be subject to FOIA and which ones would not. One of the main reasons for this is because every time you send an email or create a record related to your college, you could be creating a FOIA record. Now, for the third and final step, I have some action item recommendations for trustees in light of FOIA. On this slide, you'll see those recommendations include draft emails regarding college business with FOIA in mind. Be cognizant of sensitive information. Be cognizant of your authority to create college records. Be cognizant of your authority to bring records into the reach of FOIA through your use or possession of the same. And remember, FOIA's reach can extend to your personal email addresses and cell phones. And for some final overall trustee takeaways, please remember it's always great to understand the scope of FOIA. To remember, FOIA applies to all types of information, whether it's electronic or not. To be cognizant of records that you've used or created. To strategize with the use and creation of sensitive information as necessary. To be diligent with necessary strategies. Utilize your board chair to disseminate when appropriate. And remember, if it fits in your FOIA cup, FOIA applies. And as always, stay current on Illinois FOIA cases and Public Access Counselor opinion updates. Thank you very much for your time in this podcast today.